I'd like to call the Finance, Ways and Means Subcommittee to order for April 27th, 2021. Madam Clerk, please take the roll.
Representatives Baum, Camper, Freeman, Gant, Hawk, Hazelwood, Lynn, Ogles, Todd, Whitson, Williams, Wendell. Chairman Hicks.
Here.
You got a quorum.
Thank you very much. Members, are there any announcements or personal orders before we begin? Seeing none, we have a total of 44 bills on our regular and addendum calendars. So we're going to go ahead and get started with item number 1 on our regular calendar. Item number 1 is House Bill 1522 by Speaker Sexton. We have a request to roll to next week's calendar without objection. Roll next week. Item number 2 on our calendars by Leader Gant. Sir, you're recognized. You have a motion, second.
I'm sorry, Mr. Chairman, I didn't hear you. I was having a conversation. Forgive me.
Sorry about that. You're recognized. It's item number 2, House Bill 948.
Yeah, this is, I'm standing in the gap for Chairman Boyd. He could not be here today. And Chairman, if you'll give me the indulgence of standing in the gap, hopefully there will not be any questions that I cannot answer. But this is around, makes various changes to the Certificate of Need process for healthcare facilities and services. And I will turn it back to you, Mr. Chairman.
All right, thank you. And there is a cost associated with item number 2, House Bill 948. So without objection, we will have to place House Bill 948 behind the budget without objection. So moved. And members, back to item number 1, just want to be clear on that. We're going to be rolling to the next calendar. That will be next week, but just to be clear, that will be rolled to the next calendar. So item number 3 on our calendar is going to be rolled to the Hill. Without objection, rolled to the Hill. Brings us to item number 4. Item number 4 on our calendar has been requested to be taken off notice. So House Bill 1063 without objection, off notice. Brings us to item number 5. Item number 5 on our calendars, House Bill 693 by Chairman Doggett. It has been requested to be taken off notice. So without objection, House Bill 693 is off notice. That brings us to item number 6. Item number 6 on our calendar is House Bill 904 by Chairman Doggett. I do not see him, so without objection, we will roll this to the Hill. Without objection, roll to the Hill. All right, that brings us to item number 7. Item number 7 on our calendars, House Bill 745 by Chairman Haston. We have a request to take House Bill 745 off notice. Is that? We will back up. Do we need to?
I think it was 865 that was supposed to be off notice.
Okay. So let's back up to item number 7. Give us just a second. Let's make sure we're in the proper posture. All right, Mr. Chairman, sorry about that. On item number 7, this is House Bill 745 by Chairman Haston. Sir, you're recognized.
Thank you, Mr. Chairman and committee. What this bill does is offer high school seniors the opportunity to take a nationally recognized career readiness assessment at no cost to our students. Over 800 companies in Tennessee recognize and utilize the National Career Readiness Certificate. We often emphasize preparing our students for the next test, the next class, but this will just prepare them for their first career. With that, I'll be glad to answer any questions.
All right, you have a motion and a second. Members, you've heard the description. Any discussion on House Bill 745? Seeing none, there is a cost associated with House Bill 745, so we will have to place it behind the budget at this time and consider it at a later date. Without objection, House Bill 745 is behind the budget. All right, that brings us to item number 8. Item number 8 on our calendars, House Bill 865 by Chairman Haston, and I think this is the one that's been requested to be taken off notice. So without objection, House Bill 865 is off notice.
Thank you, Mr. Chairman.
Thank you, Chairman. That brings us to item number 9. Item number 9 is Chairman Kumar, House Bill 1028. I don't see the chairman, so we will roll this to Hill without objection. So moved. That brings us to item number 10. Item number 10 is also Chairman Kumar, and we have a request to take House Bill 1379 off notice. So without objection, House Bill 1379 is off notice. That brings us to item number 11. Item number 11 on our calendars, House Bill 427 by Chairman Littleton. There she is. Chair Lady, you have a motion and a second. You're recognized on House Bill 427 for a brief description.
Thank you, Mr. Chairman and committee. House Bill 427, it says, under the present law, the Class E felony of sexual battery is unlawful sexual conduct with a victim by the defendant or the defendant by a victim accompanied by any of the following. Force or coercion is used to accomplish the act. The sexual contact is accomplished without the consent of the victim, and the defendant knows or has reason to know at the time of the contact that the victim does not consent. This bill adds, the sexual contact with the victim occurs during the course of consultation, examination, ongoing treatment, therapy, or other provisions of professional services described. And the defendant, whether licensed or not by the state, is a physician, psychologist, psychiatrist, therapist, social worker, nurse, chemical dependency counselor, member of the clergy, or any other who provides or to provide treatment for mental, emotional, or physical condition.
All right, thank you, Chair Lady. Members, any discussion on House Bill 427? Seeing none, House Bill 427 still has a cost associated with it, so without objection, we will have to place it behind the budget and consider it very soon, as a matter of fact. So without objection, House Bill 427 is behind the budget. Brings us to item number 12 by Chair Lady Littleton. You are recognized on House Bill 951. You have a motion second. Please continue with a brief description.
Thank you, Mr. Chairman and Committee. This creates a Class A misdemeanor offense of negligently by act of omission engaging in conduct that places a child in imminent danger of death, bodily harm, or physical or mental impairment. Creates a Class D felony offense by act of omission engaging in the conduct that places a child that is 8 years of age or less in imminent danger of death, bodily injury, or physical or mental impairment.
All right, thank you, Chair Lady. Members, any discussion on House Bill 951? Seeing none, House Bill 951 does have a cost associated with it, and we will have to place it behind the budget and consider it very soon at a later date. Without objection, House Bill 951 is behind the budget.
Thank you, Mr. Chairman and Committee.
Thank you. That brings us to item number 13. Item number 13 on our calendar is House Bill 753 by Chairman White. I think I saw him come in. There he is. You have a motion to second, sir, on House Bill 753. You're recognized for a brief description.
Thank you, Mr. Chairman. Committee, if you will, bear me the indulgence to explain this, so I'll see if I cannot get this out here for a favorable recommendation, even though it does have a note, but let me explain it. Okay, the federal government passed a bill called the IDEA, or the Individuals with Disabilities Education Act, which says that all children are entitled to a free public education. But when you have a child with disabilities in our schools, in our 147 districts, 1,800 schools, they do have special medical needs. So the issue is that as they go through, the federal government does reimburse the states for this medical needs, but because of the bureaucracy, Tennessee has never worked out a way to we get reimbursements for these medical needs. Because the federal government requires you to have a physician authorization whenever these children are seen by various people in the medical field. And so only about 30% of the claims are ever handled, so about 70% are not, and so it is costing our public schools, and this has been going on for decades, I'm told, whenever this was brought to me, that it's costing our schools about $60 million a year that we're not drawing down these federal funds to reimburse the schools for these IEP programs that these children with disabilities are in. So what we did, we worked with TennCare, and we did come up with 4 specialties that we would not need a physician authorization, and they are the physical therapist, an occupational therapist, a speech language pathologist, and an audiologist. These 4 specialties, we don't need a physician's authorization that the federal government requires, so we can draw these dollars down so that we can get reimbursed. So this is really a reimbursement bill, just like most things from the federal government. You apply and you get the money back. So this is more of a reimbursement. So I'm not real sure about the physical note, but it's something that would save our state, save our schools a lot of money by getting reimbursed, because the federal government's, the dollars are there, we're just not bringing them down. And that's basically what we're trying to do with this bill.
All right, thank you, Mr. Chairman. Members, any discussion on House Bill 753? Seeing none, as the sponsor alluded to, there is a fiscal impact that we still need to work through. So without objection, House Bill 753 will be placed behind the budget. Without objection, so moved.
Thank you very much. Thank you very much.
All right, members, that brings us to item number 14 on our calendar. Item number 14 is House Bill 869 by Chairman Zachary. Second. Sir, you are recognized. You have a motion to second. Recognized for a brief description.
Thank you, Mr. Chairman. You did say House Bill 869, correct?
869, that's
Yes, sir.
correct.
Members, this is the House version of legislation as a result of the ad hoc committee that met this summer regarding the executive powers. It's fitting that actually we're presenting this today on a day where Governor Lee declared the pandemic as being over because he has been measured and steady in his leadership during this pandemic, and this legislation is for all future governors to ensure the protections and the liberties of the people of our state. This establishes the parameters around a state of emergency related to public health moving forward. It establishes a legislative council, which would have the ability to issue a stay at the 30-day mark during a state of emergency if we're not in session. It allows the General Assembly to terminate a state of emergency at any time. It also puts a 60-day provision where a state of emergency related to public health cannot extend beyond 60 days, and there are also a few reporting requirements that are included in this. I'd be glad to answer any additional questions.
All right, thank you, Chairman Zachary. Members, any discussion on House Bill 869? Question's been called. Any objection to calling the question? Hearing none, seeing none, we're now voting on House Bill 869, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 869 moves to full finance.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Members, without objection, we're going to go back to House Bill 904, item number 6 by Chairman Doggett. Chairman Doggett, you have a motion and a second. You are recognized on House Bill 904 for a brief description.
Thank you, Mr. Chairman, members of the committee. House Bill 904, as amended, seeks to expand protective orders eligibility to victims of sexual offenses and witnesses that are expected to testify against defendants that were charged with crimes involving weapons or use of force. It also requires the petition to be certified or supported by an affidavit of the victim, the informant, or witness, and specifies that good cause for issuing such a protective order may include that allowing the defendant to publish the information is likely to result in coercion, intimidation, or harassment designed to discourage the victim, informant, or witness from testifying or appearing in court as a witness.
All right, thank you, Chairman Doggett. Members, you've heard the description of House Bill 904. Any discussion on House Bill 904? Seeing none, hearing none. Chairman, House Bill 904 does have a cost associated, does have a fiscal impact, so we will have to place it behind the budget and consider it at a later date. So without objection, House Bill 904 is behind the budget. Thank you, sir.
Thank you very much.
All right, members, that brings us to item number 3. So without objection, we're going to go back to item number 3 on our calendar. I see Chairman Curcio is here. So Chairman Curcio, you're recognized on House Bill 357. You do have a motion and a second, so you are recognized for a brief description. House Bill 357.
Thank you, Chairman. Thank you, committee. Appreciate you rolling me. House Bill 357 would seek to make whole the salaries of anyone who currently works in the 21st Judicial District, moving them over to the 32nd Judicial District. Currently, that judicial district encompasses Williamson, Hickman, Lewis, and Perry County. Beginning next year, we created the newly created 32nd Judicial District. Anyone who decides to stay in their exact same chair at their desk doing the same job, but in the newly created judicial district, this would raise their pay up to what they make now. It would keep them whole.
All right, you heard the description of House Bill 357. Any discussion on House Bill 357? Seeing none, we're now voting on House Bill 357, moving on to full finance. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. House Bill 357 moves to full finance.
Thank you, Chairman. Thank you,
sir.
committee.
All right, that brings us back to item number 50. Which one? 15? Oh, yeah. I thought you said tomorrow. All right, members, that brings us back to item number 15. Item number 15 is House Bill 1501, and it is my understanding this will be rolled to next calendar. Is that correct?
That's correct, Mr. Chairman.
All right, without objection, House Bill 1501 rolled to next week. That brings us to item number 16 on our calendar. Item number 16 is House Bill 1515 by Representative Cochran. Sir, you're recognized. You have a motion second. You're recognized for a brief description.
Thank you, Mr. Chairman and committee. This bill essentially puts a formula going forward for the hotel-motel tax. Just very briefly, back in the 80s when this was initially passed, it was passed in a way where the cap was at 5%, and really it was whichever government body got to it first, either city or county. Since then, we've done a lot of carve-outs. Technically, those carve-outs are unconstitutional. This bill protects those that have already been done. So that it codifies that, and then it puts in a formula going forward where any new hotel motel tax, if a city or a county does not have one currently, they max out at 4%. So, and the city and the county can both institute that. And then it does not have to come to us for approval. This is a local action. So no longer do we have to take action on a lot of different carve-outs. This is a formula that will apply across the state. I will yield to any questions. Thank you.
All right, members, did we get a motion in a second? We do have a motion in a second. Okay, just want to make sure. All right, well, the amendment is traveling, so we are ready to discuss. Okay, we do not, yes, we do not have to place the amendment. The sponsor does not want to place the amendment on at this time.
That's correct.
That's my understanding.
That's
So we will
correct.
not be putting the amendment
Yeah.
on, so thank you, Chairman.
Thank you.
Members, in discussion on House Bill 1515 for a sponsor. Seeing none, we're now voting on House Bill 1515, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1515 moves to full finance.
Thank you, Chairman and Committee. Thank you.
Thank you, Representative. Okay, we're good. We'll just- All right, that brings us to item number 17. Item number 17 on our calendars, House Bill 846 by Representative Sherrill. There he is. You have a motion to second, sir. You're recognized on House Bill 846 for a brief description.
Thank you, Chairman and members. This is House Bill 0846 and does have amendment.
It is traveling.
Amendment number 05434, which makes the bill.
That's correct. It is traveling, so you're ready for a description.
Yes, sir. Thank you. Teachers in our prison system that work for the Department of Corrections have a difficult job, and they are essentially teaching in a reform school every day, 12 months out of the year. Right now, teachers in the correctional system are paid based on the geographical location in which the prison sits. So a teacher in Bledsoe County, for instance, County Correction Complex is paid based upon the Department of Education scale in Bledsoe County. The amendment does one key thing. It pulls all correctional teachers' pay grades up to the same level as those in the highest paid counties, such as Shelby County or Davidson County. That makes the bill.
All right, thank you, sir. You have heard the description from Representative Sherrill. Any discussion on House Bill 846? Seeing none, there is a cost associated with House Bill 846, so without objection, House Bill 846 will be placed behind the budget. Without objection, so moved.
Thank you,
Thank you,
Chairman and
sir.
members.
All right. Members, let's go back to, without objection, to item number 9. Item number 9 on our calendar is going to be Representative Kumar. All right. Item number 9 is House Bill 1028 by Chairman Kumar. Sir, you have a motion to second. You're recognized for a brief description.
Thank you, Mr. Chairman, Committee. I do have an amendment. It is 0777.
It is, let's just make sure. We do not have an amendment, Chairman Kumar.
Okay, then I'll describe the bill as it is then.
All right, let's proceed.
This came out of the Chronic Disease Prevention Task Force. It allows a municipality, county, or a county having a metropolitan form of government by local ordinance or resolution to prohibit the use of tobacco and vaping products in parks, playgrounds, public greenways, or property that is accessible to youth, and youth is defined as below age 21.
All right, thank you for this description. Members, any discussion on House Bill 1028? Any discussion? Seeing none, hearing none. Chairman Todd, you're recognized.
Is this inside or outside or both?
It's outside. It does not include public buildings.
Thank you, Chairman. Any other discussion? Seeing none, we're now voting on House Bill 1028, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1028 moves to full finance.
Thank you.
Thank you, Chairman. All right, members, that brings us back to item number 18. Item number 18 is Representative Calfee, and I do not see the representative. So without objection, we will roll House Bill 1246 to the Hill. Without objection, so moved. That brings us to item number 19. Item number 19 has been requested to, House Bill 994 has been requested to be taken off notice. So without objection, House Bill 994 off notice. All right, that brings us to item number 20. Item number 20, there is Representative McKenzie. Item number 20 is House Bill 1509 by Representative McKenzie. Do we have a motion to second? We have a motion to second. Sir, you're recognized for a brief description.
Thank you, Mr. Chair. There is Amendment Code 4004.
That is traveling with the bill.
Yep.
So you are in the correct posture for a brief description.
I think, thank you, Mr. Chair. This bill does two things. First, it utilizes alternative methodologies for evaluating child care providers. Things like if they keep nights, weekends, special care, things like that. Right now, the Boyd Center that does that evaluation just kind of has a straight line approach. So this gives some flexibility to them. Second, it encourages consolidation for smaller providers, maybe a centralized cafeteria where they can take the food from accounting, things like that, to increase their efficiencies and costs. There's a financial component, but it is absorbed within the DHS's annual child care block grant fund.
All right, Chairman, thank you for that description. Any discussion on House Bill 1509? Seeing none, hearing none, we're now voting on House Bill 1509, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1509 moves to full finance.
Thank you, Mr. Chairman.
Thank you, Representative. All right, members, that brings us to item number 21. Item number 21 is House Bill 1593 by Representative Miller, and I think it's being carried by Leader Camper, if that's correct.
Mr. Chairman. Yes, Mr. Chairman. I see you're going to have a task calendar. So do I want to wait and address it then?
Okay, that sounds good. So without objection, House Bill 1593 moves to the task study calendar. Without objection, so moved.
Thanks, Mr. Chairman.
Thank you, Representative. Thank you, Leader Camper. Item number 22 by Representative Smith is House Bill 636. It's been requested to be taken off notice, so without objection, House Bill 636 is off notice. Brings us to Representative Stewart. Representative Stewart has item number 23, House Bill 1297. Leader Camper, you recognize.
He's on his way. He said, could you roll him 5?
All right, we will, without objection, roll 5 spots.
Thanks.
So moved. All right, that brings us to item number 24. Item number 24 is House Bill 1534 by Chair Lady Weaver. You have a motion to second. You're recognized on House Bill 1534 for a brief description.
Thank you, Chairman. Thank you, members. House Bill 1534 is a great bill for our teachers, and we always want to try to do things to encourage our teachers in their profession. There is an amendment. It's running with the bill. It's 5839. And basically, this amendment removes the requirement for the State Board of Education to approve alternative teacher endorsement and licensure pathways for current and prospective educators. Requires the State Board to approve a process for the LEAs to establish a district teacher training program for the purpose of recommending eligible educators for endorsements. And 3, it requires an eligible educator that receives an endorsement to take an assessment under certain conditions. It has a corrected fiscal note, which is not significant. And in a nutshell, this bill saves the LEAs on recruitment, 1, gives the LEAs flexibility and local control, 2, and of course, we do have a teacher recruitment and retention issue, and this helps fill in those holes. I think it's a great piece of legislation. Again, it offers our LEAs, we are entrusting them. They know the teachers that are qualified to stand before their students. There are requirements in this bill. You have to have been teaching at least 6 years, and you have to be a high-quality 4 or 5 evaluated teacher. So there are bars to meet. But our teachers have been through one heck of a year with COVID, and a lot of them, this would prevent burnout. So there's a lot of good benefits this bill could do for our teachers. And so that's basically what it does.
All right, thank you, Chair Lady. Members, any discussion on House Bill 1534? Chairman Hawk, you're recognized.
Thank you, Mr. Chairman, and sponsor. Thank you, Chairman Weaver. I think it is a good piece of legislation as well. And forgive me if this committee started late. I'm the reason, and I apologize to this committee. I've been in 3 hours in Criminal Justice Committee, so I apologize. I do have a question about, and we may need to go out of session here to hear about the fiscal note. How in the world did you get the fiscal note corrected to make it not significant? And that may be a question for the sponsor, but we may go out of session to hear from fiscal review on that.
Okay, without objection. And we will let Ms. Karsner identify herself and please answer the question.
Krista Karsner, Fiscal Review Committee. Chairman Hawk, in our analysis of the legislation, it appeared that there were pathways in which the Department of Education and the State Board of Education could do this within their existing resources. And there was similar legislation last year that also our analysis this year matches up with that language of that analysis last year.
Okay. Thank you. Thank you very much,
Thank you,
Mr.
Chairman
Chair.
Hawk. Thank you. Anyone else have any other question for Ms. Karsner? Seeing none, we'll go back in session. And we are back on the bill. House Bill 1534, question's been called. Any objection to calling the question? Hearing none, seeing none, we're now voting on House Bill 1534, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1534 moves to full finance.
Thank you, Chairman. Thank you, members.
Members, without objection, we're going to go back to item number 23. Item number 23 on our calendars, House Bill 1297 by Representative Stewart. I see he is here. You have a motion, a second. You are recognized for a brief description.
Thank you very much. This is an entirely permissive bill which allows cities to create a fund that could contain private and public monies at the discretion of the mayor or leader of the town or city to study juvenile violence, homicides, and prostitution. Those are issues that affect Nashville very specifically, but no city has to do it. It's purely permissive. I know it's got a local fiscal note, but it's, again, permissive. There's no actual cost to this program.
All right, thank you, Representative Stewart. Members, you've heard the description of House Bill 1297. Is there any discussion? Seeing none, we're now voting on House Bill 1297, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1297 moves to full finance.
Thank you, Mr. Chairman, members of the committee.
Thank you. That brings us to item number 25, members. Item number 25 is House Bill 327. We do have a request to take this off notice, so without objection, House Bill 327 is off notice. That brings us to item number 26. Item number 26 on our calendar is House Bill 139 by Chairman Baum. Sir, you are recognized on House Bill 139. You have a motion to second. Please continue with a brief description.
Thank you, Chairman Hicks. This is an administration bill to help foster children. It does it in two parts. The first part expands the eligibility for the Hope Foster Child Tuition Grant. Here's how it does it. In order to be eligible for that grant, you have to have been in DCS custody for at least 1 year between the ages of 14 and 18. But we have some foster children that enter the program after they've had their 17th birthday, and so they can't get that 1 year. This makes them eligible for that grant. The second part of the bill helps foster children by setting up a liaison program for them at 5 universities. It's a pilot program, and these liaisons will serve as mentors and advocates for the foster children who have gone to college, helping them as they pursue graduation and with their retention at colleges.
All right, Chairman Baum, thank you very much. Members, you've heard the description. Any discussion for House Bill 139? Question's been called. Objection to calling the question. Hearing none, seeing none, we're now voting on House Bill 139, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 139 moves to full finance. let's go ahead and grab item number 27. Item number 27 is House Bill 1173 by Chairman Baum. Sir, you are recognized on House Bill 1173, item number 27. You have a motion to second. You're recognized for a brief description.
Thank you, Chairman Hicks. Some of our school districts are growing very rapidly. Some are adding 1,000 or more students per year and are initiating the construction of one new school building or more per year. This is a bill that would provide some additional funding for these LEAs from the state's general fund. It would be outside of the BEP funding formula. Schools would be eligible for funding through this mechanism if they've grown by at least 2% over a 5-year period. That's not 2% per year, just 2% over a 5-year period. And funding would be determined by a formula that's based on their growth, and the amount of assistance that they would receive would be capped at $7 million per year.
All right, thank you very much for this description. Members, any discussion on House Bill 1173? Seeing none, there is a cost associated with House Bill 1173, so we will have to place it behind the budget, consider it at a later date. Without objection, so moved.
Thank you all.
Thank you. Members, let's move back without objection. We are going to go back to item number 18 on our calendar. Item number 18 is House Bill 1246 by Representative Calfee. Sir, you have a motion to second on House Bill 1246. You're recognized for a brief description.
This is the bill, the Student's Right to Know, which tells high school kids what they expect, what it costs to go to college, go to trade school, or go into the military, and points out the benefits to each and what it's going to cost, what they'll gain by going to each one of them.
All right, thank you, Representative. You've heard the description of House Bill 1246, members. Any discussion on House Bill 1246? Seeing none. Yes, Leader Camper, you're recognized.
Thank you, Mr. Chairman. Thank you, sponsor, for the bill. How would we get the information to the students? Is there
It's
a
on
portal
it's
set
on a
up?
platform the Department of Education has, and this is going to expand that. It'll be available through the Department of Education. They already have the platform. They're just going to start filling it out more if this passes.
Thank you, Mr. Chairman. Thank you.
Thank you, Leader. Further discussion on House Bill 1246? Seeing none, there is a small fiscal note associated with House Bill 1246, so we'll have to place it behind the budget and consider it very soon and at a later date. So without objection, House Bill 1246 will be placed behind the budget.
Thank you, Chairman. It's more pleasant to hear you say that than Andy Holt, so.
What item? Item number 28 is the next item on our calendar. I thought he was going to say the former chairman, Mike Harrison. I didn't. Mike was in here just a few minutes ago, so I would have took that. So, item number 28 on our calendar is House Bill 1581 by Leader Camper. Leader, you are recognized. We have a motion and a second. You're recognized for a brief description.
Thank you, Mr. Chairman. Mr. Chairman, what this bill would do would create a sales tax holiday for small businesses, goods sold under $500, and food and drink sales for restaurants and music entertainment venues.
All right,
Labor Day weekend.
Sorry, Leader, I didn't mean to interrupt you.
That's all right, Mr. Chairman.
All right, Leader, thank you very much. Members, any discussion on House Bill 1581? Chairman Hawk, you're recognized.
Thank you, Mr. Chairman. And seeing that it's Labor Day, it would be quickly followed by our September session on the Tuesday following Labor Day in September. Another quiet lull in the room. Thank you, Mr. Chairman.
Duly noted. Duly noted, Chairman. Members, any discussion on House Bill 1581? Seeing none, House Bill 1581 does have a cost associated with it, so we will have to place it behind the budget and consider it at a later date. Without objection, so moved. That brings us to item number 29 on our calendar. Item number 29 is House Bill 612 by Leader Gant. You do have a motion to second. Sir, you're recognized for a brief description.
Thank you, Mr. Chairman. This bill authorizes the state treasurer to inquire with local governments and volunteer fire departments about establishing a length of service award program known as LOSAP.
All right, thank you, Leader. Members, any discussion on House Bill 612? Seeing none, hearing none, we're now voting on House Bill 612, moving on to full finance. All those in favor say aye. Aye. All those opposed, no. The ayes have it. House Bill 612 moves to full finance. That brings us to item number 30. Item number 30 is House Bill 780 by Leader Gant. House Bill 780, let me just get us to the proper posture. House Bill 780 was previously considered and placed behind the budget. We have since received a funding letter, now can move this bill on to full finance. So any objection to reconsidering our actions on House Bill 780? Seeing none, we will now consider House Bill 780, and it is properly back before us. So item number 30, we do have a motion and a second, so House Bill 780 is before us. Leader Gant, you're recognized.
Thank you, Mr. Chairman. What this bill does is it updates, these updates include modernizing the way boards or programs and licensees communicate with one another, updating licensing fee structures or removing them altogether, decreasing certain age requirements, and lowering apprenticeship hours. This bill also makes updates to the Real Estate Commission's Education Recovery Account by simplifying requirements to access funds. And Mr. Chairman, I also have been instructed to read into the record a certain statement for this piece of legislation before it gets to the floor. If you will indulge me and allow me to do that.
Yes, sir, you're recognized.
After considering and discussing, the department will set an internal practice that regulatory boards reserve funds will strive to maintain 25% of the previous fiscal year's total budget for any given program. This calculation would allow the department to approve spending for strategic items related to a given program/industry while protecting against market volatility and fluctuations and protecting the sustainability of each program. Any reserve spending would be for specific items related to the program industry from which the monies came and must be approved by the commissioners from TDCI and Finance and Administration. Additionally, funds would not be spent in a way that would put a program at risk of violating its self-sufficiency requirement found in TCA 4-29-121.
All right, thank you, Leader Gant. Members, you've heard the description and the statement that has been placed on to the record. Any discussion on House Bill 780? Seeing none, we are now voting on House Bill 780, moving on to full finance. All those in favor say aye. Aye. All those opposed, no. The ayes have it. House Bill 780 moves to full finance. Brings us to item number 31. Item number 31 on our calendar is House Bill 48. There has been a request to take House Bill 48 off notice. So without objection, House Bill 48 will be taken off notice. Thank you, Chairman. Thank you, Chairman. Item number 32. Item number 32 on our calendar is House Bill 432 by Representative Lynn. We have a motion second. You have a motion second. You're recognized on House Bill 432 for a brief description.
Thank you very much, Mr. Chairman. In July of 2020, Representative Jernigan contacted me and asked if I'd be willing to provide relief to his constituent by bringing his parcel into Wilson County. This taxpayer's property is bisected by the Davidson County and Wilson County line. Most of his home is in Davidson County, but his driveway, which is accessible to emergency services, is in Wilson County. As a result, the family pays two property tax bills, one for their home in Wilson County and one in Davidson County. Representative Jernigan had actually done, and I had actually done this before in 2012 when we brought 17 parcels into Wilson County for emergency services reasons. So we followed the same process which is prescribed in law to move the parcel. The Davidson County, the Metro Council, which has 40 members, passed a resolution last fall asking Wilson County to take the parcel, and it was a unanimous vote. The Wilson County Commission, which has 25 members, passed a resolution after that asking us to redraw the lines and take this parcel into Wilson County. And there were 24 members present that day, and the vote was unanimous. And the homeowner commissioned a survey of his property so that it could be provided to the legislature. So with that, Mr. Chairman, I hope the committee will vote today to grant relief to this Tennessee citizen and grant the wishes of the Davidson County and Metro Council and the Wilson County Commission by allowing this parcel to be brought into Wilson County. Thank you.
All right, thank you, Representative Lynn, for this description. Members, you've heard this. Any discussion on House Bill 432? Leader Gant, you're recognized.
Thank you, Mr. Chairman. Sponsor, does this affect any other major metropolitan county like Shelby County? And does it change any of the TCA code that could potentially allow a county like Shelby to annex into one of my counties, Fayette?
No, it doesn't change the code at all. The process in the code to move a county line will be unaffected by this bill. So it does not affect that.
Leader Gant.
Okay, thank you for that response. Now, what about a municipality like the city of Memphis to go into another adjacent county?
Right, this would not affect that process that is right now prescribed in code. If that was ever requested by either of those local governments, you as the legislator would just follow the process prescribed in code. After they give you a resolution, I presume passed by 2/3 vote.
Leader Gant.
Okay, let me just get for the record, this does not change any of the TCA code that would open up any possibility of that happening.
No, sir, it
Okay.
doesn't.
All right, thank you, Mr. Chairman, thank you, sponsor.
Thank you. Leader Camper.
Thank you, Mr. Chairman. Mr. Chairman, I'm hoping that it doesn't allow Fayette County to come and get half of Collierville either. So you're telling me that the county next to Shelby won't be allowed to do the same?
Not by this bill. There's a process prescribed in code, and what the process is that if, the local legislators talk about it and they want to pursue it, the county commissioner or the city commissioner would bring a resolution to his or her body asking them to either take in a parcel or give the parcel to the other city, municipality, or county. If the commission or council votes for it, then the other county that would be taking the parcel or city, then they would vote on whether or not they wanted to take the parcel. So one has to vote to give it and one has to vote to take it. And then also the homeowner or the property owner has to commission a survey of the property to make sure that we know exactly what would be moved by a vote of the General Assembly. So the local governments have to request it, both agreeing to give it and take it, and then they give the resolutions to the legislators who bring it here to committee and ask you all to vote to have their wishes passed.
All right, thank you.
I got one more question, Mr. Chairman.
Leader Camper.
Yeah. Thank you, Mr. Chairman. So with this legislation, it's only dealing with whether if I, for instance, had property in Collierville and a portion of my farm was in Fayette County, then I could seek relief from Collierville Board of Aldermen, and see if they would request that, and then should that, and I'm imagining it's only if the property is in both counties. Is that what we're addressing?
You're recognized.
No, actually, the process to move a parcel is actually already in law. We're simply following that process for half of one lot that's in Davidson County. There's a house on it. Part of the house is in Wilson, part is in Davidson. So this is half of one lot, and Metro Council has asked Wilson County to take this parcel into Wilson County. And Wilson County voted, yes, we'd be happy to take this parcel into our county. That way, this homeowner's property will be wholly in Wilson County rather than split right now. Right now, this property owner receives 2 property tax bills for his one house, one from Metro and one from Wilson County. He has Wilson County water, and there's other services that he has from Wilson County. And his cars are registered in Wilson County, for instance. And he, hopefully, his parcel will, by this bill, be taken wholly into Wilson County. The process, however, that you're asking about is actually already proscribed in law. I don't know how long it's been there. It's been there a long time, though, because I know in 2012, Representative Jernigan and I were asked to move 17 parcels because of emergency services. Davidson County Emergency Services had to actually leave Davidson County, enter into Wilson County, drive through a subdivision all the way through it to get to some homes that are in Davidson County, but inside of a Wilson County subdivision. So we moved those into Wilson County in 2012, and that's worked out very well. Now, it doesn't move voting. It does not move voting. So this homeowner will actually not be my constituent until ever we have reapportionment and those voting lines are then moved. This is only moving the property line.
Leader Camper.
Thank you, Mr. Chairman.
Chairman Williams.
Thank you, Representative Lynn. I understand the concerns that your property owner had when he purchased the property, bifurcated between two counties. I get that. I guess for me, I'm not a huge fan of this. I, like you, have had an instance where emergency services couldn't serve a community, or they were cut off from services, or quite frankly, they couldn't get affordable homeowners insurance because the ESO rating was really bad. In this instance, it's kind of a little different in that you have a property owner who wants to change his property, but there's not really a public safety issue at all. So the concern would be for me that if we continue down this vein, are we setting a precedence by doing this multiple times over? And because of that, I'm really concerned about it. And so for that reason, I'm not going to be supporting it. I've looked at this several times. In local committee, we had a great discussion on it. And when I looked at it, my fear is if you take this property today, then tomorrow the neighbor who was cut off may say, hey, I'd like to have my property taken out too. And then next thing you know, 10 years from now, we have whole areas of geography that have moved county lines. And so those lines are important and they're there for a reason. And so I apologize, but I won't be supporting your bill. Thank you.
Representative.
Well, let me just address your concerns. One, there is a process in law, and that process in law is there for a reason, because sometimes it comes up that, local governments want to move the county line for whatever purpose. Two, this property owner does have two driveways. A lot of homes will have two driveways. And his one driveway, which is in Davidson County, has a 40% grade. And so emergency services will not go down his driveway. It's a very rugged, old driveway that he doesn't actually use. He uses the driveway that's in Wilson County. And that driveway is a flat driveway that goes up to the house. And so also emergency services, when they go to his house right now, they're driving through Wilson County and getting to a Davidson County driveway because he has to call Davidson County because his house, because it's more in Davidson County, is considered being in Davidson County. But they're driving through Wilson County to get there now. And so this really is straightening out something with 911. In my county, we actually do have a problem with 911. I know when I call 911, many times I get Hendersonville across the lake. There was actually a man drowning on Christmas Eve 2 years ago, right outside my house. He had fallen out of his boat. He was boating alone. And I called 911 while running to neighbors who had boats, trying to get them to go out there. And I got Hendersonville. Had to hang up. I called again. I got Davidson County. They said, we have to transfer you to Wilson County. It was a nightmare. So we do have problems with 911. And this will straighten out, a little bit. And don't forget, this cannot happen unless the local governments vote for it. Metro Council, 40 members, voted unanimously. Wilson County, 25 members, actually 24 were there that day, voted unanimously. So first they come to you, you can say no, but those local governments have to vote for it too. So there are safeguards. And the property owner has to get a survey. His survey was $2,000. So there are a lot of safeguards. There's a lot of hurdles to jump over. This process was actually started in 2019.
Chairman Williams.
Thank you. I appreciate the representative's comments, and I understand there's a process. That And I feel like that you and Representative Jernigan have followed the process to a T. I think part of that process really is, though, getting approval here. And that approval, for me personally, is based upon certain parameters that are problematic. Driveways do not meet street specifications, but roads do. And so even though a driveway may be steep, they have, in order for a community to take over the roadways, it has to be within their street plan and meet their standards in regards to slope and grade. And so I appreciate that, but I do appreciate your hard work and diligence here. But in this instance, I'm still concerned about slippery slope of changing these properties over time for a reason that is not like the one we originally talked about. Thank you, Chairman.
Thank you. Chairman Todd.
Thank you, Mr. Chairman. Two questions primarily. The first is, will this physically be changing a county boundary?
You're recognized, Chair Lady.
Yes, it will. It's a lot, there's a home on this lot, and part of, it's putting one little section into Wilson County from Davidson.
You're recognized, Chairman.
Thank you, Mr. Chairman. Second question is, do you know whether the fiscal note took into account the expenses that multiple companies will have to change their maps?
Generally, we take into account government expenses and not private expenses for all fiscal notes.
You're recognized, Chairman Todd.
Just have a concern about that. Street names changing. We had one here that changed, and so business cards have changed, stationery has changed, all kinds of things over a name change. And so I'm just trying to assess that, and that concerns me about a boundary changing. That's just it may not be the wrong thing to do, but it's something we have to assess and think about. Thank you.
Thank you, Chairman.
Oh,
You're recognized.
this would not change a street name.
Okay, thank you very
The
much.
address stays the same.
All right, thank you very much, Representative Lynn. Further discussion on House Bill 432. House Bill 432 does have a fiscal impact, so without objection, House Bill 432 will be placed behind the budget. Without objection, so moved. That brings us to item number 33. Item number 33 on our calendars, House Bill 1344 by Representative Ogle. Sir, you are recognized. You have a motion to second.
Thank you, Chairman. This would instruct TASER to do a socioeconomic study of childhood obesity.
All right, thank you for this description. And Representative, we do have a TASER study calendar coming up, so without objection, we will place House Bill 1344 on the TASER study calendar. Without objection, so moved. That brings us to item number 34. Item number 34 on our calendar is HJR 140 by Representative Ogles. You have a motion to second. Sir, you are recognized.
Thank you, Chairman. This is a constitutional amendment that addresses several criminal offenses.
All right, thank you for this description. And members, we do have a first publication constitutional amendment calendar coming up. So without objection, we will place HJR 140 on the first publication constitutional amendment calendar. Without objection, so moved. That brings us to item number 35. Item number 35 on our calendars, House Bill 1383 by Chairman Todd. You have a motion to second. You're recognized for a brief description.
Thank you, Mr. Chairman. What this does, it changes some parts of the TCRS rules to allow retired law enforcement officers to come back to work on a limited basis for local enforcement agencies. There are a lot of needs right now, a lot of unfilled positions that we need to have filled with these experienced and certified law enforcement officers. Right now, they can only work a maximum of 120 days a year, and this would allow them to work full-time on a year-to-year basis under certain guidelines. And I'll be glad to go over those. It's strictly permissive for the local LEAs.
All right. Thank you, Chairman. Question's been called. Objection called the question. Hearing none, seeing none, we're now voting on House Bill 1383, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1383 moves to full finance. That brings us to item number 36. Item number 36 on our calendar is House Bill 1388. Chairman, do you want to take that one up or take that one off notice? Off notice. All right, without objection, House Bill 1388 will be taken off notice. Without objection, so moved. Item number 37 is House Bill 1389 by Chairman Todd. Sir, You are recognized. We have a motion to second. We have a motion to second. You're recognized.
Thank you, Mr. Chairman. This is calling for a TASER study, so it may need to go on that other calendar.
All right, thank you very much, members. You have heard the sponsor, and House Bill 1389, without objection, will be placed on the TASER study calendar. So without objection, House Bill 1389 placed on the TASER study calendar. So moved. Item number 38 on our calendars, House Bills 979 by Chairman Williams. We do have a request to take House Bill 979 off notice. Without objection, House Bill 979 is taken off notice. That brings us to item number 39. Item number 39 on our calendars, House Bill 1218 by Chairman Williams. We have a request to take House Bill 1218 off notice. So without objection, House Bill 1218 will be taken off notice. That brings us to item number 40. Item number 40 is House Bill 1009. There is a request to roll this to next week's calendar. Any objection? Seeing none, roll to next week's calendar. That brings us to the addendum calendar. Item number 41. Item number 41 on our calendars, House Bill 1130 by Chairman Farmer. You do have a motion, a second. You are recognized for a brief description.
Thank you, Mr. Chairman and committee members. What this bill does, it creates a this creates a statewide chancery court. This creates a new chancery court judge to sit in the east, the middle, and the western districts of Tennessee to hear constitutional issues that may be brought against the state of Tennessee. So that explanation, I move passage.
All right, thank you, Chairman. Members, you've heard the description on House Bill 1130. Any discussion? Chairman Wendell, you're recognized.
If there's a jury demand, does the three-panel judge try it as a jury, or do they impanel a jury? And if so, is a jury impaneled from the Middle Division, Eastern or Western? How does a jury demand work on a three-panel judge which has three separate grand divisions?
Thank you.
You're recognized, Chairman.
Mr. Chair. And I appreciate that question, and it's my understanding this is going to work. This is a trial court, okay? But it's going to kind of walk and talk like an appellate court, all right? So I don't think there'll be an issue, constitutional issues, just as the Supreme Court hears those and the Court of Appeals may hear those. They don't have a jury that will be impaneled. So
just one follow-up.
Chairman Wendell.
If a person or organization seeks redress and this statute drives them or directs them toward this three-person panel court, would that direct those who have the right to a jury trial? Would that direct them back to the regional court of venue, or would it direct them? I mean, I'm a little confused. And I'm not trying to stump you. I just don't understand exactly if I've got a constitutional right or a statutory right to a jury trial, what's the avenue or the method if this is not set up to have a jury option? And again, I'm not trying to be ugly to you. It's just I'm curious as to what the if there's no provision, I'll leave it at that. I won't keep battering you.
Chairman Farmer.
I got it. I should address it like this. This court will hear issues of law, not issues of fact. So jurors are triers of fact. This would be straight issues of law, statutory issues of law. So there'd be no need to have a jury to make those determinations of fact. So these would be legal issues. They'd be termed statutory issues, issues of statutory interpretation. Those would be left up to the courts to determine. These aren't issues of fact, like whether or not this fact happened. This is an issue of law. So the courts would make those determinations.
Chairman, just one final question. Who's the gatekeeper as to whether or not this is an issue of law or there's questions of fact to be determined? Is it the Attorney General, or is it the individual lawyers that, or is this already ripe for this totally non-fact issue because it's gone to some other court?
Okay.
Chairman Farmer.
There's certain matters that this court's set up to hear, and those matters are statutory constitutional issues, and those matters would be by statute directed to this court, this panel of judges. Okay?
That's all. Thank you, Mr.
Thank you,
Chairman.
Chairman.
I appreciate your patience.
Further discussion on House Bill 1130. Chairman Hawk, you're recognized.
Thank you, Mr. Chairman. And looking at the financial aspect of it, this sets up a new court. So this is, we're looking at roughly $1 million in future years to set this up. Where is this physically located? Where are we talking about physical location, and how do you envision the operations of this, Chairman?
Chairman Farmer.
And thank you for that question, Chairman Hawk. The way I understand this is going to be set up, that these judges will be housed, they'll have an office in the eastern, western, and middle districts of Tennessee. And when there's a case to be heard, that they would be housed here in the Supreme Court building here in Nashville. And there would also be a clerk and master set up here in Nashville with clerks to handle all the office, the back end work there. And the courts would then hear cases here in Nashville, in Davidson County.
Chairman Hall?
Thank you. And does that set up does that become a court specifically of our Attorney General? And I noticed he and his office walked in you've got pretty good backup walking in the room when you came to present this bill, so that was good. So
He may be interested in the next one.
okay, okay. So it's not necessarily the court of jurisdiction of any state attorney. It is a jurisdiction for any attorney across the state, but just happens to be set up this way.
You're recognized, Chairman.
I apologize, Mr. Chairman.
No, you're fine.
I had myself there. But no, this is set up just as a trial court, as a chancery court judge would be anywhere else across the state, except this court would be impaneled to represent fairly the eastern, middle, and western district of Tennessee, come together, hear those cases, and of course, the majority of the judges, if they're not unanimous, 2-1, the majority rules.
Thank you for your
Chairman
indulgence.
Hall.
Thank you, Chairman.
Leader Camper?
Thank you, Mr. Chairman. Mr. Sponsor, about how many cases do you expect or anticipate that they might be hearing? Have you
Chairman
some
Farmer?
level of calculation on that?
Throughout my conversations with the AOC, I believe somewhere at least 70 a year, at least.
Leader Camper?
Thank you, Mr. Chairman.
Thank you. Members, Chairman Williams, you recognized.
Just to clarify, you said this would deal with state matters or federal or both?
Chairman Farmer?
Thank you, Mr. Chairman. This would deal with state issues, state constitutional issues.
Okay. But would the court have the purview to be able to view or understand the impact of federal court decisions and how it might affect state law?
Chairman?
Thank you, Mr. Chair.
It may be too early to answer the question, Chairman.
And I believe it is.
Okay.
If I may.
Thank you. Further discussion on House Bill 1130. Members, it does have a cost associated with this piece of legislation, so without objection, House Bill 1130 will be placed behind the budget to be considered at a later date. Without objection, so moved. Brings us to item number 42 on our calendar. Item number 42 is House Bill 1132 by Chairman Farmer. Sir, you are recognized. We have a motion to second. We do have a motion to second. We also have an amendment, drafting code 7621. Is that correct?
That's correct.
We have a motion to second on the amendment. We have a motion to second. You're recognized on the amendment.
Excuse me, Mr. Chair, let me make sure that's the correct
Okay.
amendment on that. And yes, it is. Members, what this does, this sets up a statewide council and abatement council to handle and disperse the settlement funds for these opioid cases with regards to 3 distributors and 1 manufacturer and any subsidiaries thereof only. This is something we've worked with the cities, the counties, the litigating and non-litigating attorneys across the state. We've worked with it's a collection of multiple efforts here. And if I gave a percentage on how much of an agreement this is, I think we're 95% across the board right here. I haven't had one person call my office in the last week to say, hey, this is something we don't like. Okay, so I believe it's safe to say that this is an agreement with all interested parties.
All right, Chairman, thank you. And members, we are on the amendment, so to get this bill in the proper posture, let's go ahead and put the amendment on because it does make the bill. So without objection, any discussion on the amendment? Seeing none, we're now voting on the amendment 7621 to House Bill 1132. All those in favor say aye. All those opposed, no. The ayes have it. We're back on the bill as amended. Members, any discussion on House Bill 7621? Or let me correct that, on House Bill 1132 with amendment 7621. Chairman Williams, you recognized.
Thank you, Chairman Farmer. I know you've worked tirelessly on this with the Attorney General's office behind you. I just didn't get an opportunity to hear it the last time we talked about it in committee. Wanted to understand a few things on the record because these lawsuits actually started at the local level with a lot of district attorneys across the state, and the Attorney General wasn't interested in the time, but now we're interested. And so my question would be, there were 3 district attorneys across the state who filed suit against opioid drug companies, and particularly one drug company, and one of those set for trial in July in Upper East Tennessee. It's my understanding that your bill would allow for the carve-out of not just that one lawsuit that's pending, but also the 2 state lawsuits that are pending, one of which is from the Judicial 13th, which is represented by my general. Is that true?
You recognize, sir.
Yeah, and thank you, Mr. Chairman. And I believe you and I actually had a conference call with the attorney that represents your district attorney, and I believe he clarified that this bill isn't an issue. In fact, it says on page 7, section P, that for proceeds received from a statewide opioid settlement agreement with McKesson Corporation, Cardinal Health, AmerisourceBergen Corporation, or Johnson & Johnson, or affiliates or subsidiaries of those entities. It's my understanding that this legislation only covers those entities, and I believe that you're addressing, maybe is it the Endo manufacturing? Is that?
Yes, that was one of them.
Okay, and there's a carve-out for Endo manufacturing here, as I understand it.
Chairman Williams.
Thank you. The reason why I was a little bit confused is the discussion you and I had regarding the discussion we had that you mentioned previously was on a different amendment, and there are new plaintiffs or people whose suit brought against they're listed in this amendment as compared to the other. Based upon that, I didn't see Cardinal Health in the original one, but maybe they were. And so I thought maybe that had changed.
Chairman, you recognize.
And thank you, Mr. Chairman. And for Chairman Williams, what was added to this amendment is the words "or subsidiaries or entities," or subsidiaries or entities. So it's taken the subsidiaries. But McKesson had been in there the entire time, and Cardinal Health.
Okay.
Chairman Williams.
Just to follow up as it relates to how the distribution is, you were at the last committee, attempted to provide the members with props, of which you were castigated for, which I appreciate that. But we did get those. Okay. But the percentage distribution of those funds has not changed with this new amendment from the last discussion. Is that correct?
Chairman Farmer.
That is correct, and that would be 60-40 split with counties.
Okay.
Chairman Williams?
Yeah, I obviously, for the reasons why I mentioned previously, I would have hoped to see something that was more weighted towards local communities because they're the ones who were impugned most by the opioid. My district and Representative Alexander's district in Washington County had the 2 highest rates of NAS births per population in the state because of the opioid problems there. And so it's, even though this doesn't necessarily meet the distribution that I think is fair for counties and cities, I recognize that I might be in the minority there, but I think this is a good first step. Like you said, we're 95% of the way there. And I do think that as we go forward and look to codify what it is we're trying to negotiate terms on, that we'll take into consider the cities and counties as individuals as well as the state as a whole. But I appreciate the chairman and his hard work on it.
Thank you, Mr.
Chairman Farmer.
May I? And I just want to remind everyone, out of 100% of these dollars, all but 15% is going to end up at the locals at some point in time. We just have certain amounts that are unrestricted to the locals, and a certain amount that's going to flow through the abatement fund. But anything the locals go to and say, hey, we want to be reimbursed for X, Y, and Z, that's going to end up back in their pockets. So it's just a matter of how it's going to get there.
Chairman Williams.
I don't disagree at all with the chairman as it relates to that. I do think that those members like my general and the folks in my community that have treated these folks that are addicted to opioids know best how to distribute the funds, in my opinion, and a commission, albeit great and interesting, might not take into consideration the local specific needs of those people that were impacted in that community. And if one might not get a full understanding of what that is sitting in Nashville in a committee room. Thank you.
Thank you, Chairman Williams. Leader Camper.
Thank you, Mr. Chairman. The chairman asked the question that I was concerned about. That was the distribution back to the locals. So I got my answer, Mr. Chairman.
Thank you, Leader Camper. Chairman Hawk.
Thank you, Mr. Chairman, and thank you to the gentleman behind me who did mention the concerns from Northeast Tennessee, and I think that we have taken care of that in this amendment, so thank you very much. I evoke smiles sometimes when I talk about the good old days in this committee, and I think there's actually only one member on this committee. I was not here when the Tobacco Master settlement took place, and that there's always some trepidation going in as we look at a settlement of this nature because of the master tobacco settlement from all those years ago. So it sounds like we're moving in the right direction, but just to put that on the record that we don't want to see a similar outcome where all those dollars went to general fund and became the discretion of the state. We want to make sure that these dollars get distributed to communities to provide the help that our citizens and our communities need. So I want to put that on record that is the intent of this legislation, and as you just stated, the eventual outcome of these dollars will be directed that way.
Chairman, you recognize. Chairman
Mr. Chair,
Parker.
just for the record, that is an accurate reflection of the intent of this legislation.
Thank you, Chairman.
Thank you, Leader. Further discussion on House Bill 1132. Seeing none, there is a cost associated with House Bill 1132, and so we will have to place it behind the budget and consider it at a later date. Without objection, House Bill 1132 will go behind the budget. All right, members, that brings us to, thank you, Chairman. That brings us to item number 43, House Bill 157 by Representative Beck. He's been waiting patiently back there. Sir, you have a motion and a second. You are recognized for a brief description on House Bill 157.
Thank you. Thank you, Mr. Chairman and committee. I come to you today with good news. The Predators are on a hot streak and in a playoff position right now, and with just 8 games left in the regular season. This is House Bill 157 by myself and Senator Hale concerning the sales tax recapture policy that is presently in place at Bridgestone Arena. The Preds just negotiated a new lease with Metro government, and we are seeking to extend the recapture policy in coordination with that lease. I have Kyle Clayton here, Vice President of Operations, if anyone would like to ask him any questions, or with that explanation, I'll field questions. Thank you.
All right. Thank you, Mr. Sponsor. Members, you've heard the description of House Bill 157. Any discussion on House Bill 157? Seeing none, we're now voting on House Bill 157, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 157 moves to full finance.
Thank you, Mr. Chairman and committee.
Thank you for your patience. And that brings us to item number 44. Waiting patiently in the back of the room is Representative Chisholm. House Bill 798. You're the one we've been looking for today. You were the last item on our calendar. Not to put any pressure on you, but you're recognized on House Bill 798. We do have a motion second. You're recognized for a brief description.
Thank you, Chair and Committee. What this bill does, it limits to 4 years the amount of time after completion of an improvement to a street, sidewalk, or a highway that a claim can be brought against a local government to recover damages associated with injuries or wrongful death which occurs as a result as a deficiency in the design, the planning, supervision, observation, and construction of the improvement. With that, I renew my motion.
All right. Thank you, Representative Chisholm. Members, you've heard the description of House Bill 798. Any discussion? Representative Ogles, you're recognized.
Thank you, Representative. So, for instance, in my district, we have 840 bypass that was designed, and then after years and years of debate back and forth, we've recognized that there are some design flaws that are going to have to be remedied. Would this stop those families that have had injuries or sustained major injuries from recouping settlement from the state for those deaths that have occurred at those bridge embankments?
Okay, so this bill right here is not for the state highways, I believe. This is for local governments. So in Memphis, for example, we have a trolley system that's over 100 years old. And what this bill does, it allows the cities to still be on the hook, so to say, for the maintenance and the upkeep, but for the actual construction and design, the city's not on the hook for that.
Representative Ogles, is that satisfied? Members, any further discussion on House Bill 798? Seeing none, we're now voting on House Bill 798, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 798 moves to full finance.
Thank you, Chair. Thank you, Committee.
Members, give us just a second here. I think that we've completed. All right, members, that completes our calendar for today. Do we have any further business coming before the committee? Seeing none, without objection, we stand in recess. Oh, I'm sorry. Hold on one second. We do not stand in recess. Chair Lady Hazelwood, I apologize. You are certainly recognized.
Thank you, Mr. Chairman. Finance Full will meet in House Hearing Room 1 in 10 minutes. 10 minutes.
Thank you very much. With that said, any further business? Seeing none, without objection, we stand in recess.